The eviction process can differ from county to county, but they more or less are the same. The process includes filling out the forms, serving the documents, attending the trial, and waiting for judgment. Every eviction process is different and dependent on the lease rental agreement signed by the tenant and the landlord. It's always best to exercise meticulous file keeping on the part of the landlord to avoid errors that could be exploited by the tenant, especially the history of rent payments. It's advised that both landlord and tenant must read their lease thoroughly and clarify everything before signing on the dotted line. The lease can often make or break an eviction lawsuit. It's also advised that a landlord should try to work things out with a tenant outside court. A landlord resorts to filing for official eviction proceedings only in extreme cases. In this video, we'll discuss what landlords should refer to when evicting a tenant. You should confirm procedures with your justice court to make sure the entire process goes as smoothly as possible. Now, if you need specific legal advice, consider talking to a lawyer to answer any questions you may have. In the state of Tennessee, a landlord can evict a tenant for multiple reasons. A lot of these factors rely on the lease terms stipulated in the written contract. In most cases, the first step to every eviction is that the landlord must provide the tenant an official notice to quit. The number of days associated with the notice to quit will depend on the reason for eviction. The notice must comply with the rules stated in the Uniform Residential Landlord and Tenant Act of Tennessee. One of the notice requirements in a notice to quit is how many days tenants can remain on the property before they face an eviction hearing in front of a judge. The notice must state the tenant has violated a term, and the notice must be given to the tenant by the landlord before proceeding with an eviction lawsuit. No matter the reason for eviction, the landlord cannot do a self-help eviction, which is an illegal form of eviction that is considered disorderly conduct on the part of the landlord. The most common reason for eviction is the failure to make a timely rent payment. A landlord can evict a tenant for failing to pay the rent due. Rent is considered late in Tennessee 5 days past its due. This means a tenant may still catch up on rent within a 5-day period. For example, if rent is normally due on the 25th, then it's considered late if rent still has not been paid by the 30th. However, an extended grace period that gives more time to pay rent due may be available if indicated in the lease rental agreement. Before a landlord can start with the eviction lawsuit for failing to pay rent, the landlord must provide the tenant with a written eviction form called a 14-day notice to pay. This notice informs the renters that they are required to move out of the property or pay the rent within 14 days in order to avoid eviction. If tenants who are being evicted for failing to pay rent on time manage to pay all rental payments in full to the landlord before the 14 days are up, the entire eviction process stops and they can continue staying within the rental premises. A lease agreement can vary between tenants. Landlords and tenants are required to uphold the terms of the lease agreement at all times. The landlord can evict a tenant for a lease violation in Tennessee. The landlord must provide the tenant a written notice called a 14-day notice to comply, which gives the tenant 14 days to pay the costs associated with repairing their lease violation. However, if the violation is incurable by paying for repairs, a landlord is not legally obligated to let a tenant fix it. Should this be the case, the landlord must give the tenant notice called a 14-day notice to quit, giving the tenant time to vacate the property within 14 days. Lease violations include damage to the rental unit, smoking in non-smoking areas, falsely claiming to need a service animal, too many people living inside the rental unit, and housing a pet in a pet-free rental unit or rental premises. The landlord may continue filing for an eviction lawsuit if the tenant fails to pay for repairs and/or remains inside the rental unit after the given notice period. The tenant must vacate or else face an eviction lawsuit. If a tenant has engaged in illegal activity on the rental premises of a Tennessee property, the landlord must give them a written notice called a 3-day notice to quit to move out of the property. Should the tenant remain on the rental premises after their notice period ends, the landlord may continue to file an eviction lawsuit. Tennessee law takes into account the health, building, safety, and housing codes. Should the rental unit violate a housing code or any other codes and fails any health and safety inspections, the landlord must issue a 3-day notice to quit and allow the tenant a 3-day period to vacate the property. If the tenant is unable to vacate the rental unit within 3 days, then the landlord may continue filing for an eviction lawsuit. Violations under this could include not throwing out the trash for long periods of time, inviting bugs and/or rodents, damaging the electrical wiring of a unit, and ruining the plumbing fixtures of a unit. A Tennessee eviction process does not allow a landlord to evict a tenant without good cause. As long as the tenant does not violate any rules from their lease, they can stay until the rental period ends. However, a tenant may be evicted if they stay in the property even a day after their written lease ends, but have not arranged for a renewal. This type of eviction notice usually only applies if the landlord wants to end the tenant's lease. The required notice time given to a tenant by the landlord must depend on the tenant's tenancy type or their lease, and could be either a 10-day notice to quit or a 30-day notice to quit. Should the tenant remain in the rental premises even after their notice period ends, the landlord may continue to file for eviction proceedings in order to evict the tenant from the property. After the notice period has passed, the landlord may file an eviction lawsuit. Successful evictions rely on correct filings, so the landlord must file all the forms correctly in the right court. The steps in filing include proceeding to the justice court the rental property belongs to, and this could be a circuit court or a general session court, fill out the forms, and pay the filing costs. What about the timeline? Well, it takes between 3 to 30 days before a landlord can file a complaint. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template or create your Tennessee eviction notice by clicking on the link in the description below. This includes a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Now, keep in mind the step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want is to go to court only to find out you did the first process incorrectly. The next step in a Tennessee eviction is serving the summons and complaint to the tenant. The commonly used form for a summons and complaint in the state of Tennessee is a detainer warrant. The landlord must not serve this document themselves. The document should contain information such as the date and time of the court trial. The eviction process in Tennessee allows a professional process server or a peace officer to serve the document. It has to be delivered 6 days before the eviction hearing is scheduled if the method used is posting or mailing. The detainer warrant has to be served through one of the following methods: personal service, where the detainer warrant is served to the tenant or anyone residing with them in person; posting service, where a copy of the detainer warrant is left in a secure and visible position by the entrance to the tenant's rented property; or mailing service, where the server mails the documents via certified mail or first-class mail. After the summons and complaint is served, an answer is not required from the tenant for an eviction hearing to be held. They only have to show up to the hearing. Either the landlord or the tenant may request a continuance of not more than 15 days. What about asking for possession? A motion has to be filed to obtain judgment and get a judgment for possession. In a Tennessee eviction, the landlord has to provide a strong argument backed up by solid evidence against their tenant in order to win. Should the tenant fail to show up to the hearing, the landlord may win by default. A tenant can file an appeal even if the landlord has already won. Now, what if the tenant disagreed and filed an answer? During the court hearing in an eviction process in Tennessee, the landlord has to support their claim with evidence and show it to the judge. This includes, but is not limited by, the following: a copy of the deed and the lease rental agreement, rent receipts, rent ledgers, bank statements, witness statements, and photo and video documentation of the violations committed by the tenant. An eviction hearing is scheduled at least 6 days after the tenant received the detainer warrant. Tenants have 10 days to file an appeal once judgment is passed in favor of the landlord. Once the landlord wins a Tennessee eviction, and provided the tenant does not file for an appeal or reconsideration, the court will issue a writ of possession 10 days after the judgment is issued. The writ of possession is a court order which informs the tenant they must move out of their housing on the property, or else they will be forcibly evicted. The final step in the eviction process in Tennessee is to move the tenant out of their home on the property. Tennessee laws dictate a tenant must vacate the property before the writ of possession is issued, because once law enforcement officers receive the writ, they must execute it immediately. No grace period is given in the state of Tennessee. Only the appropriate law enforcement officers are allowed to forcibly remove a tenant from the property. The state of Tennessee requires a landlord to store any property left behind by the tenant for 30 days. Tenants should be free to reclaim their property during that period. If they fail to reclaim the property within that time frame, the landlord can get rid of it however they see fit within state laws. On average, it takes 4 to 8 weeks for a complete eviction process in the state of Tennessee. Now, if the tenant disagrees with the eviction request and they reply to the court, it's important you keep extremely good records of everything so that you can provide proof to the judge and win your case. This part can make or break your entire eviction request in the event of a dispute. You can stay organized by keeping a physical paper trail, scanning documents, storing and backing up every file using Dropbox, Google Drive, OneDrive, or any other option that is easily searchable, or using property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything you can imagine. This is used best when you also scan every document into your software. If the tenant doesn't pay rent and they dispute that claim, it's important you show the judge the following: your lease agreement showing the terms of the agreement, when rent is due, and any penalties for late payment, all payments showing all previous payments, how they were normally made, like check, credit card, or ACH, and what date they were normally paid on, any payment returns, if their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also, show any fees your bank may have charged you and any penalties you are owed according to your lease agreement. All messages, where it's important to show if you sent your tenant automated or manual payment reminders by text, email, letter, or mail. And while it's not usually needed, it can still be beneficial to show that the tenant was aware of the situation and that they had time to solve the problem. This is why it's always best to have everything in writing instead of any phone calls or face-to-face meetings. If you are evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, you can be confident the court will rule in your favor. Video. If you didn't catch them in the act, the next best thing is to record a video with your phone of any damages or the lease violation. Pictures. They say a picture is worth 1,000 words. Well, in this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to see by email or printed. Lease terms. Once again, show the court which term they violated in their lease agreement. Don't worry if you don't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. Let's talk about self-help eviction. Examples of illegal self-help evictions include changing the locks, taking the tenant's belongings, removing the front door, or turning off the heat or electricity. Tennessee state laws specify how much money a tenant can sue for if the landlord has tried to illegally evict a tenant through some sort of self-help measure. In almost every state in the U.S., a landlord must never try to force a tenant to move out of the rental unit. The tenant can only be removed from a rental unit after the landlord has successfully won an eviction lawsuit. Even then, the only person authorized to remove the tenant is a sheriff or a constable. Tennessee law has made it illegal for a landlord to personally remove the tenant from the rental unit. Now, what are the potential penalties for a self-help eviction? Landlords may be liable for the tenant's court costs and attorney's fees. Tenants may also have the right to stay. A tenant can also sue you for actual damages plus violations and may ask for an injunction prohibiting any further violation during the court action. What other laws should landlords be aware of? There may be eviction moratoriums, and there may be stricter rent control policies brought on by the pandemic. Local governments have implemented strict measures to protect the rights of tenants who are experiencing hardships. It's also wise for Tennessee landlords to check out laws on a security deposit. The security deposit can also protect the landlord in case the tenants violate any terms in the lease rental agreement or fail to pay rent. And finally, here are some frequently asked questions. Number 1 is, can you kick someone out without an eviction notice in Tennessee? The answer is no. The landlord cannot force a tenant to move out without an eviction notice. They could be convicted for forceful eviction of a tenant in Tennessee if they skip the proper eviction processes and fail to give the tenant an eviction notice. Even if a landlord has won a case, they must wait for the court order called writ of assistance for the appropriate law enforcement to remove the tenant from the rental premises. Question number 2 is, which eviction methods are illegal? In addition to self-help eviction, evictions made due to retaliation or racial discrimination are not allowed. The following acts fall under this category. The landlord attempts to evict a tenant because the tenant is involved in a tenant union or organization, or the landlord attempts to evict a tenant because of the tenant's race or sexual orientation. Question number 3 is, what is a limited liability company? Otherwise known as an LLC, a limited liability company is basically a corporation or company that owns an entire property. If a company that is considered an LLC takes part in an eviction proceeding, then an attorney is required in order to represent it. Question number 4 is, what is the difference between a general sessions court and a circuit court? Simply put, a general sessions court is usually where most minor evictions begin. It has the jurisdiction to dismiss or decide upon minor misdemeanor cases, or, if need be, it can raise the matter to the grand jury in more complicated cases. Cases discussed in the general sessions court can include traffic violations, orders for protection, or initial or preliminary eviction hearings, etc. Meanwhile, a circuit court is where an eviction case ends up if it involves any form of compensation for damages to a certain amount, usually more than $25,000. A variety of cases can end up in a circuit court, and in the case of eviction, this is where monetary disputes are usually settled. Question number 5 is, should I get a lawyer for my eviction hearing? Hiring a lawyer is an option for a landlord who can afford it. A lawyer can offer many benefits. First off, they can take care of the entire process for you so that all you'd have to do is show up to the eviction hearing. A lawyer can assist individuals in understanding the Uniform Residential Landlord and Tenant Act of the state of Tennessee. Well, that's it for this video. If you want more real estate content for your business, make sure you check out our YouTube channel for more DoorLoop videos such as what is a pet screening and why is it important, and pros and cons of month-to-month leases. Remember to like this video, share it, and of course subscribe to our channel. Thanks for watching. See you next time.